Well, I strictly limited mine to 6 minutes, so you should have 2 minutes to catch up.
Well, I know you think that that's 8 minutes provided for speakers, but don't forget to walk up time when you're not getting time. But you're already here, so I'm hoping so. We often do catch up. Is that a question? Excellent. Muchos gracias.
And in future things, you guys always forget about federal. There's only small.
Do you know what? In the last few years, you're right, but originally we made sure we did it each year, and someone else just... Well, what we did was the Canada Labour Code update, and Grossman did it each year initially, but we didn't get a lot of keep doing that federal thing in the feedback, but someone else just made the exact same comment, so I'll get it back on.
My question is more specific on the Canadian Human Rights cap.
Okay.
Because it's only 20,000.
All right.
The highest award to date has been 10,000 on the general.
Okay.
So I'm wondering if the thoughts are that the Ontario cases will start creeping into the Canadian jurisdiction.
I'm Matt, by the way.
Helen Patterson.
Nice to meet you.
I'm actually the CIBC.
Oh, yeah?
Yeah. So I work with Norm. Actually, I'm a client. I'm in HR now, but I wasn't.
I'm glad you did.
So, anyway, it's good to
I'll make sure the federal thing's on next year.
No, what do you think it's just, even if it's next year?
No, I think we should touch on it. I left it off quite intentionally because there didn't seem to be a lot of interest in it. But you're the second person already who's asked me, so that means I've been on. Okay. Yeah.
Political. How did the fundraiser go?
I don't know. I wasn't there.
There you go, Mel.
Thanks a lot. Okay. All right. And what I'll do is, like in the fall, is when we make phone calls.
No problem.
Okay.
Yeah, coming up on a year.
Mr. Vassos! When did you sneak in here? Someone wanted me to point you out to them.
Get your bodyguard with it? And my point, I can be helping to run one campaign, but if somebody called me trying to sell me a ticket for last night,
I hear you. There's going to be a Bay Street one, I'll call you. Last night was the diversity dinner.
I'm not diversity. Did you have any Jews there at all?
Howard Brown was.
Oh, God. Somebody on his 50th birthday, no less.
Yeah, exactly. He has the same birthday as me. Is that
happy May Day.
Thank you. Isn't that an unfortunate coincidence of?
You see, the campaign is loaded with commies.
Well, he says to me, I assume you're coming. This was in advance of the event. And I said, no, actually, about 39 years ago, less a day or two, it was pretty much determined that I would be with my family on May 1st. And he says, your birthday's May 1st too? And I said, I'm pretty much certain I'll get a phone call from him now every year for the rest of my freaking life.
Because it's made it. It's very easy to remember.
Well, that's what I feel apologizing to my friends for never remembering their birthday, and they do.
And next year's the big 4-0.
Big 4-0. The countdown has begun.
Yes.
Dawn's a little upset at me for even focusing on it because she's 4 years older than I am, and I told her that she was being too sensitive and making a big deal when she turned 40.
I turned 40 on my honeymoon.
Oh.
In Greece.
Oh.
And when they brought out the Geri arranged a little cake, a bunch of American college girls backpacking joined in singing "Happy Birthday." Happy birthday, dear sir. Head flops on the table. Kill me now.
I gotta tell. Okay, Anna, you want to get us back on time?
Okay, we're going to start the next part of the program called Spot the Employee. we've been proceeding along at a very leisurely pace, even though the previous speakers didn't feel that. Now we're going to step it up a notch, and each speaker will have 360 seconds, 6 minutes. And our first speaker is Jeff Mitchell, who is going to talk to us about who is an employee. In this day and age of every person wanting to be an independent contractor, and CCRA taking a somewhat different position about that issue, I can think of nobody better than Jeff to address the issue. He's a hard worker at BLG. I understand he's got a little more heavy lifting coming up as I leave and as 3 of my colleagues go on mat leaves all at the same time in July. He's truly one of the up-and-comers. I used to say that about Matt. He's there now, and I was right with him, and I'll be right with Jeff. Jeff?
Thanks, Randy. As Randy said, my topic this morning is focusing on the distinction between independent contractors versus employees. And as everybody knows, that's a very fact-specific inquiry. And what I'm going to do is I'm going to start with Supreme Court of Canada decision in 2001, 671112 Ontario Limited versus Sagaz Industries. And the main issue in the case was an issue of vicarious liability between 2 corporations. In the course of that issue of vicarious liability, the question came up as to whether the marketing company that had been retained by the primary company was in fact, the primary individual of the marketing company was in fact an employee of the corporation, or whether they were true independent contractors. And that was relevant in the case because vicarious liability could obviously flow much more easily if they were in an employment relationship as opposed to an independent contractor relationship. So the matter progressed through the courts and eventually came up to the Supreme Court of Canada. And the Supreme Court of Canada first set out several different tests that had been used over the years in determining whether someone was an independent contractor or an employee. They looked at the control test, which focuses on the degree of control that the alleged employer has over the worker in terms of hours of work, method of performing the work, and location of work. Then they mentioned the integration or control test, which focuses on how much is the worker's work related to the primary objective of the main alleged employer. And the focus of that inquiry is really, of that test is really, could the primary corporation get its objectives met without using the services of the alleged independent contractor? The closer the independent contractor's work is to the employer's main objective or main work, the harder it is to show that the individual is not integrated into the organization. So that's the integration test. Then they looked at the independent enterprise test, which is a whole separate test, which focuses on whether the worker has their own business. And that focuses on the question of whether the worker performs services for others or whether they're exclusively involved with this employer, whether the worker acts as an independent operator, in other words, identifies him or herself to the public as an independent operator on tax returns and the like. The Supreme Court of Canada, with its usual clarity, said that all the tests were legitimate. So lots of direction there. And depending on the factors in each individual case, one test might be more or less appropriate. What the court did say, though, is that at the end of the day, the main objective in looking at independent contractor versus employee status was whether the individual was focused on an independent profit-making enterprise. And the actual words the court used were, is this person in a business on his or her own account or on the account of the alleged employer? So that was the question the court asked. And in my view, that question really focuses on the last of the 3 tests that I stated earlier, which is the independent enterprise test. So is this person in a business on his or her own account? The court then went on and identified several primary factors that it would be considering in determining whether this person was in a business on his or her own account. And the court stressed in saying it that these were only factors and that other factors might be determinative in other cases. But the primary factors that the Supreme Court of Canada decision considered important were, first of all, the control over the worker's activities that the main employer exercised. That again refers us back to the first test, which is the control test. So in terms of hours of work, in terms of location of work, those kinds of issues, the control that the main employer has. Second factor that the court indicated would be significant was whether the alleged independent contractor owned his or her own equipment. So did this person have an investment in the business? Did he or she, whatever the nature of the business was, did they show that they had their own equipment or facilities or office space, all of those factors? The third factor that the Supreme Court of Canada mentioned was whether the alleged independent contractor actually hired other employees. That would be significant because that again shows an investment in the business. The next is the familiar risk of chance of profit, risk of loss. And this focuses on whether the business is in truth an individual profit-making enterprise, or is the person really just getting a flow-through of steady income? To the extent they've got a risk of loss, it shows that they are engaging in a business. To the extent that they have a guaranteed income or a guaranteed flow-through of income, it shows that they're more dependent on the employer. The last factor that the court mentioned, okay, is the responsibility for management and investment. And just by way of concluding comments, in terms of the three tests that I mentioned earlier, later courts, after the Supreme Court of Canada decision, have mentioned that the focus seems to be shying away from the integration test. So focusing less on how integrated is this person in the main employer's enterprise, and focusing more on the nature of the person's business and whether it's a true business on its own account. So I would say the objective and the focus in terms of looking at independent contractor status is really on the nature of the enterprise and not so much on how that worker is involved in the main employer's business. Thank you.
Thank you, Jeff. Our next speaker is Ed Canning of the Ross and McBride firm in Hamilton. I grew up in Burlington, and the only paper we had to read there was the Hamilton Spectator, and who writes the employment law column but Ed Canning. A great guy. He's a serious player, and he's argued an employment case in front of the Supreme Court of Canada, something which Matt and I have tried to do but couldn't succeed. And we're very fortunate to have Ed here. Ed?
It would have been better to have argued it and won. But as a result of my loss, you now cannot fire the spouse of somebody you hate. So you're welcome, all of you. Once upon a time, the law was somewhat simple. Employees without written terms as to their termination entitlements were awarded reasonable notice, and independent contractors received the benefit of many tax write-offs against income, but were not entitled to notice. All was right and just in the universe, or was it? Over the years, the court's willingness to draw a clear line between these two categories of workers has started to dissolve. An intermediate category of worker has begun to evolve called dependent contractors, and there's a typo in my paper, I call them codependent contractors, but maybe it's kind of Freudian. These intermediate workers were entitled to reasonable notice of termination if the facts of the relationship revealed that they were more like employees than independent contractors. And this case law, as surprising does exist. I was confronted in a case with this last December that never got to the end of trial, but my first reaction to this kind of suggestion of this middle ground was like, what's this law about? But when you start to look at it, and especially the Alberta case I'm going to be talking about, there's extensive case law from almost every province. It's emerging. Two cases released in September of 2001 from Alberta and Ontario are emblematic of the point. In the Alberta case, a married couple owned a corporation that provided appliance transport to Woolco stores in Calgary for 16 years. They had about 9 employees. They owned all the equipment. The employer was often involved in the discipline of the moving company's employees. The married couple went to employee parties and had employee discount cards. It was a completely exclusive relationship. After 16 years, they showed up at a store one morning and were told their services were no longer needed. They sued for reasonable notice, and they won. The employer's lawyer argued that the case law supporting this proposition was bad law and should be disregarded. The judge found that while the case law was still emerging, it was good law, which was appropriately responding to the diverse forms of working relationships that are emerging in these times. The Alberta judge found that if there is significant duration and permanency to the relationship, significant reliance or closeness in the relationship, and a high degree of exclusivity, the company qualified as a dependent contractor entitled to reasonable notice. The Alberta judge adopted the public policy Bardall approach to determining notice, but adapted it to this intermediate category of worker/company. Reasonable notice considerations included the exclusivity of the relationship, the time needed to reestablish a viable business, and the extent of staff and equipment involved. A mirror of the Bardall test transposed into terms describing corporate activity rather than an individual's aspects or work history. The court found that in most cases, dependent contractors would not be entitled to as much reasonable notice as a true employee, and that's an important finding that's mirrored in the Ontario case. The more the facts resemble that of a true employment relationship, the higher the notice period will be. In this case, after 16 years of exclusively doing this job, they were given 9 months reasonable notice. So there was obviously a diminishment in the notice that would have been given to a true employee. The Ontario case released in the same months was quite different in that the dependent contractor had signed an agreement indicating that either party could terminate the relationship without notice. This is called the Aqua case. The Ontario judge focused on the integral part that work plays in the lives of individuals and the inequality of bargaining power that often exists between workers and employers, and it refers to the Supreme Court of Canada trilogy of cases that you're all familiar with. In this case, an independent commission sales agent worked on his own for the company for a year and a half before the relationship was terminated. He was in charge of sales for the Barrie area and was held out by the company as the Barrie branch manager. He could sell non-competing products and controlled almost all aspects of his work on a day-to-day basis. The court decided that the contract this plaintiff signed just wasn't fair. The provision dispensing with notice of termination was unconscionable, and there's a saying that either party could terminate without notice. That's what he signed. The court decided it was unconscionable based on an unarticulated inequality of bargaining power. The court wrote in a provision requiring reasonable notice. Similar to the Alberta case, the court determined reasonable notice based on public policy factors. Like the Alberta case, the court noted that it would not be appropriate to give a dependent contractor as much notice as a true employee. And then one sentence later, after making that statement, the court awarded this person 5 months lost income after a year and a half of work, which makes you wonder what he would have got if he was an employee. I've been advised that at the appeal of this decision, it was actually conceded by the appellant that if not for the written provision that was struck down, there was a legal possibility of awarding reasonable notice to this non-employee. So they didn't even debate whether this dependent contractor category existed. The Ontario Court of Appeal overturned the trial decision, stating that there was no factual basis for the finding of unconscionability. The no-notice termination provision stood. The lesson for lawyers advising employees is that where a written term prescribing termination right is absent, think twice before you send somebody on their way who's an independent contractor telling them they have no case. Remember, you don't have to obtain a finding that they were an employee and run the risk of them having their tax returns reassessed. There's this happy middle ground of dependent contractors who can have their write-offs and notice too, although less notice than if they were a true employee. The lesson for employer counsel is that, of course, a written provision dealing with termination rights is crucial. If that is absent and your client receives a demand letter in an alleged dependent contractor case, think twice before writing a buzz-off letter. This case law is out there. A modest offer to settle may be the best choice. Results in these cases are unpredictable. The test is so malleable that a court can find 100 ways for the independent contractor to fail or pass the test without contradicting existing case law. The lesson for lawyers who represent both employers and employees is that either way, you get to open a file.
Thank you, Ed. Our next speaker is my old friend Jack Siegel from Blaney McMurtry. He's one of Canada's top Workplace Safety and Insurance Act counsel. And for those of you with a political bent, Jack, while he's retired now, is, to my understanding, the only person in Canada who completely understands the Liberal Party of Canada's Constitution. But he's not here to talk to you about what's going to happen at the Air Canada Centre this November. He certainly will enlighten you about the employer-employee relationship in workers' comp. Jack?
Thank you, my lord. Now, the topic here, I guess, is under the Workplace Safety and Insurance Act, it matters. I prefer to phrase it as under the Workplace Safety Insurance Act, it matters. So at the end of this, you tell me. On February 28th, in Provincial Offenses Court, Judge Boguski dealt with the matter of Tips Incorporated, its 2 guiding minds, and levied $900,000 in fines against the company, $100,000 in fines against the individuals, and ordered the corporate defendant to pay $4 million in restitution to the WSIB for underpaid or completely undeclared premiums over a period of 23 months. Now, this was a matter of out-and-out fraud against the WSIB system, but the entire investigation was triggered by a fatal motor vehicle accident where Tips claimed the driver of the vehicle to have been an independent contractor, or using the term as it appears in the WSIA, an independent operator, when in fact that person was an employee. Now, keep in mind that most provincial offenses are a strict liability. And some in the Workplace Safety Insurance Act actually are mens rea offenses that use the word knowingly or willingly. But if it's strict liability, the message is awfully clear. You better get it right. Now, there's no point in a session like this in going through the applicable test, and you've already heard about that from somebody else. Keeping in mind, however, that in workers' compensation, there's the protection of a privative clause. The approaches taken by the appeals tribunal have been upheld consistently. They've never been overturned on a JR. And I've included some material with the paper to help address some of these circumstances. A few recent cases, the board policy document, questionnaire that the board uses in general non-specific industries, and reference to help you find the questionnaires that the board will use in the specified industries: logging, construction, trucking, couriers, and taxi drivers. Their policy also refers to a questionnaire for the retail industry, but I couldn't find that on the website. That would address things like the Beckers or the Max Milk type of cases. Are you a manager for them, or are you an independent? So the question then is, why is all this, or where is all of this so important? Well, there's the right to sue. An independent operator who's injured while providing services can sue anybody involved for his or her work-related injuries. On the other hand, an employee is precluded, if the employment is covered under the legislation, and that's most areas, from suing his or her own employee. If the employee is in Schedule 1, which is, again, most the industries that we would deal with in our practices, they can't sue any other Schedule 1 employer or the employee of such a person. Now, what does that mean? Well, let's take a typical case of an MVA. Vehicle number 1, vehicle number 2 collide. You can't sue the other guy if both of you were working in covered employment. But it arises in other contexts. Consider a trucker unloading equipment, a load at a customer's premises, and a stack of pipes falls on his head, crushing his legs. No matter how badly secured those pipes were, and there may be charges under the Occupational Health and Safety Act, if he was an employee, he's precluded from suing everybody involved. And I'll raise just a little mental teaser, and there's a little more discussion. Most of you are probably familiar with the Prinzo case. WSIA was not argued as a bar to the action, but if it was an injury arising out of the employment that this woman suffered, was it open to argue that she should have been proceeding under the workers' compensation legislation? Clearance certificates. Now, this is clearly an area that's not well understood. And despite all the principles of independent contracting, in workers' compensation, where a principal hires a contractor or a subcontractor, and that subcontractor or contractor is the employer of somebody else, the principal is the deemed employer. And if there's any default of premiums down that food chain, the principal is on the hook. Clearance certificates from the WSIB will help ensure that you have protection. What they mean is that for a period of 60 days, the board waives any liability for the principal. An employer has an obligation to report accidents. If you're not the employer of the person who hurt, surely you want to render assistance, but you don't have to report it to the board. An employer has a duty to cooperate in early and safe return to work. to reemploy for as much as 2 years after the date of the accident, to report payroll and pay premiums if your industry is covered under Schedule 1. And that's usually something you can figure out either from the board's website or from the employer classification manual that the WSIB publishes, and it's available in most decent law libraries. That's the area where the Tips case arose, and most of the charges related to breaches of the reporting obligations, 23 consecutive months of unreported premiums or unreported earnings, reducing the premium, $28,000 a month in fines. And then there's experience rating. I'm on my last paragraph. If your employee is injured, it's like your car insurance. You have an accident history that causes your premiums to go up. If you have a good record, it goes down. Therefore, it's important as well to report on the ones you have to, but not to unduly claim on people who are not your own employees.
As Randy noted at the outset of our session, the last half hour of our program is entitled "A Judge, a Mediator, and Two Lawyers Were on a Panel." Our distinguished panelists are here now: Peter Israel, Christine Thomlinson, Mr. Justice Nordheimer, and Kathleen Kelly. I point that out by way of a reminder that we'd appreciate it if you would forward your questions over the course of the session. Feel free to pass them down and wave at me. I'll come over and grab them so that we have those questions in advance and we can fully utilize that half an hour at the end of the session. We can also pass the questions to the panelists so they can prep their answers. Not that they need to, of course. I'm also asked to announce that the paper that should go at tab 13 of your binder, it will be available for you to pick up on your way out. Creative Plaintiff's Actions by Martin Doane. And last but not least, our next two speakers are going to focus on employment contracts, beginning with the Vassos of Koretsky Vassos. George Vassos has been practicing since the dawn of time. You don't mind me mentioning that, do you, George?
No.
He is a partner at Koretsky Vassos. He has a master's degree in industrial relations, and he is a certified human resources professional. He is going to focus on REPAP.
Thank you very much. Pleasure to be here today. Randy, I got here late, and when I arrived, you started talking about you leaving the firm and 3 other lawyers going on mat leave. Is there
No connection.
no connection? Okay. I'm here to talk about a case named REPAP, and on the quick law version, it's a 36-page modern-day legal soap opera. It's a June 2002 decision of Justice Lax in the Ontario Superior Court, and it's a great story because its main themes center on an everlasting human fault: greed, greed, and more greed. It may make for a great movie of the week someday. The cast of characters includes REPAP Enterprises, a Canadian public company in the forest products industry, and its board of directors. One of the villains in the soap opera is Stephen Berg, an American lawyer and businessman, as well as the director and chairman of the board of the directors of REPAP. Now, boiling this case down to its essentials, the case really has 3 focuses. The first one being Mr. Berg's obligations as a fiduciary to REPAP. The second one being the obligations of the REPAP board of directors as fiduciaries to REPAP. And the third one being the focus for our purposes, the sweetheart employment agreement in favor of Mr. Berg. Now, Justice Lax made the following findings in this case. First of all, that Mr. Berg breached his fiduciary duties to REPAP because of the manner in which he negotiated and presented his agreement to the board of directors for approval. Secondly, that the compensation committee of the board failed in their own obligations to establish a prudent or reasonable process that led to an employment contract that was neither fair nor reasonable. Thirdly, that the Berg employment agreement unfairly disregarded the interest of the REPAP shareholders. And fourthly, that the business judgment rule did not shield the employment agreement from judicial scrutiny. It's now a day and age when executive compensation and corporate governance are under significant scrutiny from all sectors, from shareholders, regulators, the public. So what was all the fuss about in Mr. Berg's case? Well, it related to his employment contract and the provisions in that contract, which included a 5-year employment term with automatic renewals, a signing bonus of 25 million shares, a stock option grant of 75 million shares, and when you added all those shares together, that amounted to 13.4% of the company, a multi-million-dollar capitalization bonus, an immediate pension credit of 8 years, executive employee benefits, and a liberal change of control and termination provision, which was worth only a paltry $27 million. In striking down the contract, Justice Lax relied on a number of findings of fact, including that there was consistent evidence at trial that before Mr. Berg became the chairman, everybody seemed to be agreed that there was no need for an executive chairman, nor for Mr. Berg to perform any senior executive or management role. Notwithstanding this, Mr. Berg forged ahead with his employment contract. Mr. Berg did not have any particular skills to bring to REPAP that were not already available through its senior management. Mr. Berg's appointment brought no material benefits to REPAP that would justify the hiring of a senior executive officer with a lucrative employment contract. As one director put it, Mr. Berg's interest was not in making money on the common stock, his interest was in getting rich off an employment contract. One of the most startling aspects to the case is the extreme haste and dispatch with which the board dealt with the employment contract in question. The compensation committee spent all of, on the evidence, 5 to 7 minutes reviewing the contract. The board wasn't that much better. They did spend approximately a half an hour. But as part of what went on, they retained a compensation expert from Mercer's to review the contract, and then they put handcuffs on the consultant, providing her with a very short period of time to review the contract and virtually no background information on the company or its situation. In striking down the contract, Justice Lax found a clear concern with breach of fiduciary duties by Mr. Berg. One of the most startling aspects of this case for me was Mr. Berg's conduct in relation to legal counsel and counsel's role in the negotiation of the employment contract. The bottom line, essentially, was that there was no negotiation. And not only did Mr. Berg retain legal counsel on behalf of the company, he was then the contact person relative to the employment contract. Are you getting the drift of this case? One of the main lessons to be learned from REPAP is that employment contracts must not only be substantially fair, but the process by which an employment contract is made must also be fair. And to state the obvious after the facts that I've given you, the contract must not be overly generous to the point of significantly reducing the assets of the corporation. I see it's time to get to the moral of the story. And the moral of the story, very simply, is that pigs get slaughtered. It's a new world out there post-Enron. This case is under appeal to the Court of Appeal. The early line from Las Vegas is that the Court of Appeal will uphold the trial judge. That's my 6-minute story, and I'm sticking to it. Thank you very much.
Enforceability pitfalls and practice tips. That is the topic that Neena Gupta has agreed to present for us today. She is a partner at Goodman & Carr in the Human Resources Management Group. Neena has an LLM, and she's an adjunct professor at the University of Toronto, teaching, among other things, no doubt, employment law. Neena Gupta.
Thank you very much. I think our version of the story on REPAP is pigs get fat, but hogs get slaughtered. Now, I commend to you Mr. Vassos' paper, because which is at tab 8, which has a really useful checklist of 13 points on which an employment contract that is signed, sealed, and delivered might otherwise be found to be invalid. And given that I have 6 minutes, I'm not going to go either through my paper or Mr. Vassos' paper, but I think it's worth reading and taking the time. I thought what I would do is just point to you some cases you might know, or variations on cases you know, that might be useful to you in practice. One of the perennial problems are employment agreements containing onerous terms that are signed after the commencement of employment. The Supreme Court Canada case in McGuire and Northland Drugs suggested that continuing employment itself and the forbearance of the employer from terminating the employee continues to be good consideration. And no court really has wanted to challenge the Supremes on this 1935 decision, although they have found remarkable ways of trying to get around it without actually overturning it. An interesting decision is Porter and Kohler, Canada, which I actually discuss in my paper. And Justice Malloy did something very interesting. She said that continuing employment was not consideration in this particular case. And it's at page 9-9 of the paper. And there was a couple of reasons that Madam Justice Malloy distinguished a number of cases. Number one, she said, there was no indication that the employee thought or was advised that he would lose his job if he didn't sign. And two, there was no intention that Kohler could show that it was going to fire if the employment agreement wasn't signed. And then she throws in this sort of throwaway comment that's really interesting. She says, and in any event, Mr. Porter would have gotten huge notice, maybe a year or so, if he had been terminated for refusal to sign the employment agreement. And the implication of that is, yes, maybe continuing employment is consideration if there is an intention to fire. But if you're going to fire, you have to give lawful notice. And for an employee that's been around for eons, that may be a year or so. So, interesting practice point, if you're going to try to implement an employment contract after an employee starts, you have to give fresh consideration, or you've got to do this, we'll fire you if you don't sign this. Always really good for employee morale, I must add. And if you don't sign it, we'll give you lawful working notice or lump sum, which sometimes defeats the purpose if you are acting for an employer, because they don't really want to pay 12 months notice, because usually in the employer drafted contract there is, we'll give you Employment Standards Act minimum notice. Okay, so practice point number one. Practice point number two, be wary of obsolescence. And I've tried to be fair in my paper, where I've looked at cases which uphold old provisions, termination provisions, and ones which do not. Interestingly, the courts seem to fixate more on title and position rather than the lapse of time. And I've quoted an interesting provision in a case called Dolden and Clark Simpson, a BC decision, which essentially said it is the employer's responsibility to refresh the contract if there's a change of position and title. Otherwise, we may hold that the contract is obsolescent. By contrast, there have been contracts that have been upheld 20 years later, but the person actually is in the same position, still vice president or general manager. One practice point in reviewing this paper I've noticed that if the contract specifically averts to looking at changes in position and saying this contract still remains effective despite any promotions, lapse of time, changes in seniority, compensation, blah, 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 I think the courts will uphold it. And there's an interesting provision I've quoted which appears in the Computer Associate Standard Form, an American employer who no doubt doesn't like any kind of notice provision. And they actually specifically avert to changes in position. So if your employer contract, if you're drafting a contract for an employer, you should look at that. If you're an employee lawyer, you should be wary of that provision. I want to conclude by referring briefly to two decisions which aren't strictly contract enforceability decisions, and they're discussed starting at 9-21 of my paper. One is Dupre and Shonix, a BC Supreme Court decision. This is really a sad set of facts. Employee starts as director of retail sales and is fired 5 months later. He has an Employment Standards Act minimum clause which is enforceable. It is alleged during his probationary period that he didn't do his job, except that he landed an $80 million contract in the first 5 months, so it's really hard to say he didn't do his job. And what the court implicitly found in this case is that his boss wanted him out so he could collect the commission himself. He doesn't quite say it, but you should read it because he skirts around it. He wants to be very careful, but that's really what's happening in this case. So Dupre gets 6 weeks notice. I would have thought he would have gotten commission for 6 weeks, and sorry, it just happens that way. The judge in this case did a quantum merit judgment for $200,000, saying that would have been the premium for a year's sales. That's what he said would be fair. So, you know, if you've got really unconscionable facts, you know, you might want to use quantum merit and unconscionability as a pleading. That's in BC. So my time is up, so I will just alert you to the fact that if you have contracts which cross borders, American forms of contracts in Canada, Ontario forms of contracts being used in BC, note that the judges are very protective of their own, and there are a dozen ways of trying to get around foreign contracts. And for interesting reading, I commend that you read the trial decision in Buchanan and Geotel, where Justice Ferguson essentially took on a U.S. employer and applied Canadian law to disastrous consequences for the employer, quite frankly. I conclude by saying the best thing that happened to this employee was to get fired at the top of the stock market, because he probably would have kept his stock options for months and months had he been retained by the company, and instead of being paid off at $100 a share, he would have been paid off at 15 cents a share. And those are, in 6.5 minutes, my practice points. I hope they're helpful to you.
Thank you, Neena. Moving right along, we're going to head into the ESA 2000 area. We have Paul Boniferro, a partner at McCarthy Tetro, a leader in the employment bar. There's an excellent paper in your materials. I noticed in reading it that he says there's been about 325 OLRB decisions, about 59 separate arbitral decisions, and a handful of common law cases. Paul?
Thank you, Randy. You just stole my speech, because that was the only way I was going to fit this all in 6 minutes, was just to tell you the number of cases. The reality is I had a different approach as well, and the paper that's in the binder I commend to you is excellent, and not because I drafted it. I didn't. One of our associates did, but I tried to convince her that the only way we could fit this in is to answer the question, how has it worked so far? And the answer is poorly. Sit down and we'd be done. As Randy said, there's been an enormous amount of case law, both at the Employment Standards branch, now being adjudicated by the Ontario Labour Relations Board, reported and unreported arbitration cases, and court cases. The reality is the majority of those cases, when you actually get to sit down and try and read some of them, all indicate that the majority of them have been settled, and they just outline the details of the settlement. Particularly with the Ontario Labour Relations Board cases, you should be aware that in those instances where the case has settled, the board has approached it in at least 3 separate ways. One, it simply states in its decision that the application has been terminated. Or 2, it states that the matter's been settled and sets out the terms and conditions of the settlement. Or 3, and this is the important one, I think, in terms of a practice issue, it adjourns the application sine die for a period of up to 1 year on the condition that the application will automatically expire or terminate if the parties do what they agreed to do in the minutes of settlement. So it's a bizarre way of sort of documenting the settlement, but you'll find a number of cases that are documented in that way. In terms of the applications for review, I just want to point out, and it's in the paper, there are certain conditions that need to be met for applying for judicial review. First, it has to be in writing. The person, and this is in most instances the employer, for whom the order is against, has to pay into the director of employment standards the amount of money in trust. And thirdly, the application has to be made in 30 days. I was astonished at the number of cases that were not granted judicial review for the simple reason that the employer had not paid the money into the Employment Standards Branch. Now, that's for a number of reasons. I can tell you, having done these applications on behalf of employers, often you apply within the 30 days, you decide, are we going to pay the money or not, and proceed with the review, and in many instances it either settles or the employer decides within that 30-day period this is not something worth pursuing and therefore doesn't pay the money. But you'll find an astonishingly high number of cases that are not reviewed because of the failure to pay. A relatively rare occasion where the review doesn't proceed because of not being applied in a timely fashion. In terms of the arbitration cases, there's a couple of cases cited in the paper, and I just want to point out at least one of them to you. One deals with public holidays, and the issue is whether or not the act, or the collective agreement rather, provides for a greater right or benefit on the public holiday side. And in this instance, it provided for 11 statutory holidays and 2 floating days. And the question was, is that a greater right or benefit because the collective agreement said that it should be paid at straight time, 8 hours, and the Employment Standards Act would require that it be paid at 11.5 hours because that was the regular working hours of the employee. Another case in there, Zayres Market and UFCW, in that particular case, the arbitrator looked at whether or not, again, there was a greater right of benefit. And the issue is, do you look at it in the aggregate for all of the employees in the collective agreement, or do you look at it on an individual basis? The arbitrator in that case said both. So you look at it in the aggregate to determine whether or not it is a greater right or benefit. But in this particular instance, when we're talking about vacation pay, you have to review that decision or that concept every single time you're either paying the employee the vacation pay throughout the course of their employment or upon termination to determine whether for that specific employee it's a greater right or benefit. So it's almost like it's a twofold test. The last case I want to mention to you is a court case, and this is the best proof we have that the Employment Standards Act is not working. For those of you that have worked with the new act, you know that there is a provision in there that says you can't pursue the same claim in both Employment Standards Branch and in the civil courts through wrongful dismissal. And there's a mechanism, a slight cooling off periods, so you have 2 weeks to withdraw your Employment Standards Act complaint so as to not negate your right to a civil action. In this particular case, the employee started both action in a civil court and filed an Employment Standards Act complaint. They didn't withdraw their Employment Standards Act complaint until 10 weeks after it was submitted. The employer immediately brought a motion to have the civil action dismissed, saying the Employment Standards Act complaint continues because it wasn't withdrawn within the 2-week period, and the court said no, we can't look at it as that restrictive. They allowed the civil action to continue and basically ignored the 2-week cooling off period. So there you have it, the Employment Standards Act. How's it worked so far? Poorly. Thank you.
Our next 2 speakers are going to focus on the doctrine of just cause. Cause after McKinley, what can we glean from judicially considered, will be addressed by Mary Porjes, who is a leading member of the employment bar here in Toronto. She practices in all areas of employment and workplace law, but most interestingly, I find from her bio, she was born in Budapest. I did not know that. Mary Porjes.
Thank you very much. I'm not going to do this in a Hungarian accent. And I'm also so glad that His Honor didn't introduce me, because the last time he introduced me, he said I had a quarter century at the bar. So I thank you so much for avoiding that. My topic is, what can we glean from judicially considered with specific reference to the McKinley case? And I'm going to talk a little bit about the McKinley case, give you some practice pointers, and then talk about some of the case in my paper if I have time. What can we glean from judicially considered? Not a lot. Not a lot of surprises in the cases that follow McKinley. Let me tell you a little bit about McKinley. We all remember McKinley. McKinley was the case that got headlines in the newspapers: dishonesty not cause for dismissal, lying to employer not cause for dismissal. That's not at all what McKinley says, but it certainly grabbed the headlines when it was decided by the Supreme Court of Canada a couple of years ago. Mr. McKinley was the controller in the BC Tel group of companies, and he began experiencing some health problems. He went off work on the advice of his doctor, but he said he wanted to return to work to a job that was less pressureful. He was suffering from hypertension and high blood pressure, so that made some sense. His employer said that they would look for another job for him, but didn't offer him another position. And then, while he was still off work, his employer terminated his employment. He was offered a severance, he didn't accept it, and he sued for damages for wrongful dismissal. This is where the case gets interesting. 3 days into the trial, the employer found a letter from Mr. McKinley's doctor, and the doctor said that there was a medication called a beta blocker, which, if Mr. McKinley went back to his old job, might control his blood pressure. And the allegation was that Mr. McKinley had been dishonest about his medical condition and the treatments available to it. The allegation of dishonesty was that he had deliberately withheld the information about the potential for this new medication and what it might do for him, and that with this new medication he might be able to return to work. Now, Mr. McKinley was successful at trial, but the BC Court of Appeal overturned the trial decision and sent it back for a new trial, and that's how it got to the Supreme Court of Canada. The issue before the Supreme Court of Canada was a number of issues, but for our purposes, the issue was whether any dishonesty in and of itself suffices to warrant an employee's termination, or whether the nature and the context of this dishonesty have to be considered in assessing whether just cause for dismissal exists. We know what the answer is to that question. The Supreme Court of Canada was very clear. The Supreme Court said no cause exists in Mr. McKinley's case. It just shows you again that when you get facts like this, you know, the decision is somewhat foreseeable. The Supreme Court of Canada said the test was, does this employee's dishonesty give rise to a breakdown in the employment relationship? Does the dishonesty breach the faith inherent in the employment relationship? The Supreme Court of Canada talked about the principle of proportionality, which we know is let the punishment fit the offense. Okay, I've set out a number of cases in my paper. I want to talk about some practical things. What do we learn from McKinley? What is the contextual review? Let's look at the context of this employee's employment. What does it just, my thesis is it doesn't really tell us anything new. What it tells us is that we have to exercise due diligence before an employee is terminated with cause. And this applies when you're acting for an employer or for an employee. For an employer, you have the luxury of being able to do it before the fact to avoid an unnecessary and expensive lawsuit. For the employee, you do the diligence after the fact to see if a lawsuit is warranted. This raises the issue that we've talked about many times. It comes up with progressive discipline, comes up with dismissal for cause, which is the knee-jerk reaction. Something happens, and a client wants to dismiss an employee, and our job as lawyers is to put the brakes on. Not to put the brakes on too long, because we don't want to raise a condemnation defense, but to put the brakes on and do some due diligence. I've got some practical issues in the paper. Let me go through some of them quickly. We're all really busy, but we have to take the time to investigate what the issue is that is cause. What's in the personnel file? How long has the employee been employed? What's the performance history? Has the company tolerated the conduct in the past? Is the behavior an aberration? Is it a health problem? Is it a medical problem? Is it a marital problem? A dependency issue? Is EAP the right answer as opposed to a termination? Are other employees involved? Has this employee been unfairly singled out? What is the relationship between the employee and his or her manager? Is this a grudge termination or is it a true termination? We have to look at all of these issues, do some due diligence before the termination is carried out, because the problem is, of course, if you do it wrong, it's damages for wrongful dismissal. You have the potential of punitive damages, damages for mental distress, especially if you're talking about an employee who has emotional problems. What the Supreme Court of Canada said was that the employment relationship should not be lightly severed for cause, and the punishment must fit the crime. Thank you very much.
The horror, the horror. Condemnation and the journey into the heart of darkness. That's what we've entitled the next topic, to be presented by Jonathan Pitblado, who is a fellow Dal grad. Jonathan's here, isn't he? Yes, he is. Who volunteered to join our faculty. And I raise this as an example because each year Randy and I stand up and say, please, please volunteer, suggest topics. And we do our best to include people who do come forward, and we want to encourage each of you to consider doing so yourself. Now, Jonathan is a small claims court judge and has been since 1999. He teaches at Fanshawe College, and he had a very interesting case that he thought you might find useful. Jonathan Pitblado.
Good morning. I'd like to talk to you about two cases and some practical points regarding the simplified rules. The two cases are the Nossel decision, which I call the Sword of Damocles decision, and the Chambers decision from 2002 in the Court of Appeal. The Nossel decision from 1985 from the Court of Appeal is the leading condemnation case in Ontario. And basically it says that if an employer does not act for a period of time with respect to bad behavior by the employee, the employer has condoned it. Fine. But what Nossel goes on to say is that if the employee screws up again in the future, the old misdeeds can be added to the new misdeeds. So basically, it's condoned, but it's not condoned, which is why I call it the Sword of Damocles decision from an employee point of view. What Chambers helps us with a bit from 2002 is to figure out if the sword is actually a sword or whether it's just a paring knife hanging over your head. What happens in Chambers is that he had a 2-year fixed-term employment contract as an insurance broker, and the employer could have just let him go at the end of the 2 years. He had various misdeeds which they warned him about and said you might be fired if you do it again, et cetera, et cetera. When the 2 years came to an end, they essentially rehired him by a letter, an indefinite term hire, and they said you can stay around at reduced commissions or you can go. He, being between a rock and a hard place, said, well, I'll stay. 3 months later, of course, there was another so-called misdeed and they fired him. So those were the facts, essentially. So what the trial judge had to deal with is how do you weigh the old misdeeds? Nossel doesn't tell us anything about the weight to be given to the old misdeeds. And the arguments that seem to appeal to the trial judge were that the employer had already factored in the old misdeeds when it essentially rehired Mr. Chambers at a reduced commission. So from a contractual intention point of view, they had an employee who was a known quantity. He wasn't the best, but he wasn't the worst. They were getting him cheap, end of story. And that seemed to be very attractive to the trial judge. The other companion type of argument was that, an analogy to criminal law, that you shouldn't double punish. In other words, if he's staying on at reduced commissions, that's his punishment for the old misdeeds. And what the trial judge said is that he was giving very, and he emphasized very, very little weight to the misdeeds done during the 2-year fixed-term employment contract. The case made its way up to the Court of Appeal, and they had no problems with what the trial judge did. The other points I wanted to bring out here today, perhaps of more practical benefit, are some points about the simplified rules. I bring all of my wrongful dismissal cases under the summary trial provision, so I avoid the viva voce trials like the plague. The reason is that, and Chambers was one of these cases, the reason is that you can do the best direct examination possible. You have all sorts of time to craft your affidavit, put in your exhibits with it as best you can. You'll know what the defense case is because you'll get their affidavits. And now under the new version of the rule, of course, at the pretrial stage, you can ask for reply affidavits. What I did in chambers, which is of some note, I think, from a practical point of view, is I brought a motion mid-trial without any advance notice to strike portions of the defense affidavits for failure to comply with Rule 39014. Some of you, if you do a lot of motions work, know that's the rule for motions and applications when affidavit evidence is not strictly put in correctly. The advantage of that approach is twofold. Number one, if you strike it out, there goes some of the cause allegations, you don't have to worry about it. Number two, even if you're unsuccessful, you've planted the seed of doubt in the trial judge's mind that this particular evidence is hearsay, it's not particularly strong evidence. So you've kind of got your argument in before the end of your trial, and those of you who've done a lot of simplified rules know that your time for argument is very limited at the end of the trial. So you're kind of cheating by getting it in that way. And the Court of Appeal validated that approach. The other thing that was done in chambers, and I've done it pretty much in every cause case since, is to always do a demand for particulars with the defense, so you know exactly what they're saying and what they're not saying. Because remember, if they refuse and you have to bring a motion over it, your client can't be cross-examined on his or her affidavit. So subject to ethical considerations, that you have to have a valid purpose for bringing your motion, you can still bring it, and you'll know the case that you have to meet. My final point is with respect to costs. The Court of Appeal allowed the costs given by the trial judge, which were $10,000, half of the docketed time of $20,000. That appears to run counter to the decisions of Colleen and Mesber, which say that costs should be very limited in a simplified rules matter. Thank you very much.
Thank you, James. The next section we're moving into is damages. Marty Doane is from the Pallier Rowland law firm, and I can tell you from personal experience, there's nobody better than Marty at being creative. For the past year or so, I've had firsthand experience with his creativity, and I regret that I'm not going to be able to either try or hear the case. But Marty also, his firm sends out a very creative Christmas card every year, too. This year, he was pictured looking like a very beat-up Eddie Shack, a scrappy-looking hockey player with a black eye and black teeth. And ladies and gentlemen, I present to you Martin J. Doane.
I think it's a very frustrating time, frankly, to be a plaintiff's employment lawyer. You've got a set of structures out there in which you've really got to divide your attacks among a variety of different forms. People's working lives generally aren't confined to contractual obligations or private law obligations or human rights considerations. They involve an interplay or a mixture of these things. And I think over time you're going to see something of a revolution in the way that employment law cases are dealt with, much like the revolution that occurred in administrative law when a generalized standard of procedural fairness was read in and cases proceeded then on that much simpler platform, much like the revolution in the law of restitution in which, after centuries really of having all of these very finely detailed ways to plead a restitution case, the courts just basically said it's all about unjust enrichment. You've got three different criteria to meet, and just call it one thing and get on with it. As it stands right now, you've got to bring different proceedings under human rights legislation. Typically, if you've got that as part of your case background, you've got to sue if you've got a contractual issue or a tort law issue. And really, I think the goal should be for the creative plaintiff's lawyer is to figure out a way to amalgamate all of these considerations and drive your bus. And the problem with human rights code matters and administrative law matters before other tribunals is that often you don't drive the bus. In the human rights context, you've got to submit the case to the commission processes it, it decides whether or not a board of inquiry will be appointed, and it can be a very frustrating, lengthy, time-consuming process and ultimately not very satisfactory for your client or you as a practicing lawyer. But there are techniques, I think, out there in which you can amalgamate some of these considerations and try your case in the way you want to try your case in one form, preferably before an Ontario Superior Court justice, the most independent kind of hearing you're going to get. One of the ways you can do that is take a look at the Discriminatory Business Practices Act. I don't think a lot of people know about this act, but it in fact mirrors to a large extent the Human Rights Code. And under this legislation, you have grounds of discrimination set out, and surprisingly for many people, under Section 9, you can actually bring an action in the Ontario Superior Court, a court of competent jurisdiction, suing for general damages and special damages and punitive damages for a violation of the discrimination provisions in the code. So it's a really wonderful way to combine human rights issues in an ordinary civil action. A second thing to look at as a way of really bringing to bear issues relating to mental distress, mental health, and things like that is not to couch your claim in terms of the intentional infliction of mental distress or aggravated damages principles. There is a common law tort of failure to provide a safe working environment. It's age-old. You can also sound one of these things in contract as an implied term as well. The case law is legion. It's all set out in Stacey Ball's text. And of course, because it's not an intentional tort per se, the standard and how you prove it is much less. You also don't have any problems, I think, with the exclusivity provisions of the workers' comp legislation in the main. And I heard there was a comment earlier about the recent decision in the Court of Appeal. The provision in the workers' comp legislation is very limited. The mental stress that you suffer in order to have that claim dealt with under that legislation has to be the result of an acute incident and not a more generalized over time building up of mental stress or psychological harm engaged by your working relationship. A third area you might want to consider is just the basic doctrine of implied terms. I repeatedly plead in my wrongful cases that it's an implied term of the employment contract that the parties will obey the relevant laws applicable to the employment relationship. And if you look at the doctrine of business efficacy and how implied terms are dealt with, it fits the model very nicely. And who's going to argue that it isn't an implied term of the employment relationship that the employer and the employee will obey all relevant laws? So you can back end a lot of these administrative standards into your civil court matter just through that mechanism. A fourth thing you might want to think about, it's underutilized, is the oppression remedy under the corporation statutes. It's a very elastic remedy, and it's a bit difficult if you're an employee, just a basic employee, to utilize. You have to be able to fit yourself into a shareholder, creditor, or some like aspect of a relationship with a company. But for many people who have shares in private companies or public companies or are in a creditor relationship, you can fit it, and it's a valuable piece. Finally, you got to think about class actions. I think over the next few years, you're going to see class actions utilized as a quasi-form of labor relations legislation, in effect to create something very similar to a unionized working environment on an issue-by-issue basis. Thank you.
Thank you, Marty. We'll move from hockey players to rugby specialists. Hugh Christie is a partner at Gowlings and a leader of the employment group there. He's a qualified arbitrator, and I note that he served as an arbitrator of rugby disciplinary matters and a match commissioner around the world under the International Rugby Board. but he's not here to talk to you about rugby. He is here, he could very well, but he's here to talk to you about employee references. Hugh?
Thanks, Randy. The people in this room will have reached the reasonable conclusion that the Governor General and Council decided that Randy Echlin knows a lot about employment law and he'd make a great judge. That's wrong. They picked him for good reasons because of his absolutely ruthless use of that clock. We've all heard about the chill written in the trade press and written in some legal press around employers giving job references. I want to talk to you about the legal issues surrounding those considerations. At the end of this chat, I'd like you to come to the conclusion that most of the worries from a legal point of view around giving job references and then following up on the phone are US based, and they ought not to govern your client's decisions here if you act for employers. The worries coming from the states are that if you give too generous a reference, you might get sued by a subsequent employer who said you sold us a pig's ear rather than a silk purse. And you might get sued by the employee if you didn't give a fulsome and generous enough one, and we all know about that. I'm going to suggest to you that neither of those worries are well-founded. What we have heard of in our law is Wallace. And Wallace and its derivatives make it clear that if you don't give a letter of reference at all, that's bad faith. If you give a perfunctory letter of reference, that's also evidence of bad faith. And I'm going to suggest to you that it's not too much of a reach to say that if you then, when the phone call comes, say, I'm sorry, I can't talk to you about that individual, that equally could be evidence of bad faith, and that's the real worry employers should act upon. All right. Quickly then, we're going to talk about letters of reference, follow-up phone calls, qualified privilege, because I got to talk about some law in this group, and then some advice to give to clients. One, whether to give a written reference, I think we're over that hurdle. The answer is yes, and it ought to be fulsome, not perfunctory. There has never been a case, I always hesitate in this group saying that because someone will have found one. There has never been a case, to my mind, of a subsequent employer successfully suing in Canada saying, I got a bill of goods on this employee and it's because of your reference prior employer. What about the phone call follow-up? There are going to be two situations. One is when the follow-up is following up on a letter of reference. That's easier because a letter of reference in a termination case in particular is going to have been managed. You will probably provide for who will answer the phone call. You may even have provided for the text of what will be said or the substance of it as between employee and employer. So that's easy. The difficult one comes when an employee resigns, gives a reference, and then the follow-up phone call comes cold to the line supervisor who isn't expecting it. That's the case that Natalie Zinman and I had in December on behalf of an employer who was subsequently sued along with the supervisor for defamation by the employee who didn't get the conditional offer of employment fulfilled because it was revoked after the phone call. So that's where the rubber hits the road in terms of defamation damages or risk of them in my submission on reference phone calls, because the call will be cold, the receiver of the call will be unprepared, they likely won't be a specialist in the area, the caller will be pressed for time. In our case, it was an outsourced telephone reference check, basically telemarketer with lots of pressure, and they got paid on how many phone calls they closed in a day. So the average length of a phone call was 3 minutes. It came out in cross-examination. You'll also deal with the problem of the person making the phone call will take notes, will probably have a form that they fill in with the issues to be covered. The person who receives the phone call, unless they have a significant presence of mind, will not take notes because it's not their job. So the big risks are overstatement, saying things you don't know, and resorting to gossip because the person receiving the phone call thinks they have to say something, and they will be forced into making a judgment by the caller. That's the caller's job. All right. Now, employers ought to decide who takes the call. There is a strong, I would say, interest in thinking that it ought not to be the line supervisor. It ought to be someone in HR who is knowledgeable in the issues and a professional in the area. The call is likely covered by qualified privilege. That means that if there is a reciprocal duty on both sides, in other words, the person making the call and receiving the call both have it in their job description to, in the normal course, have this conversation, it will be covered by qualified privilege as long as the information conveyed is a bona fide, honest belief. And if that's true, whatever is said, whether opinion or fact, even if it's wrong, is covered by the privilege unless there is significant evidence of malice. That means that even intemperate language can be used. As Thomas Paine said, freedom of temperate expression is no freedom at all. Now, so the issue is, if it's covered by the privilege, then you can have a frank conversation. The number one detail that has knocked out the privilege in past cases decided is when the referring employer initiates the phone call. Why? Because that's the best evidence out there of malice. What interest would the referring employer have in making a phone call to a subsequent employer about the employee? So, don't initiate the phone call if you're an employer, and don't phone your friend, because then you're not in the normal business relationship. You're phoning a friend who happens to have worked at the employee's past employer. All right? That's the privilege. Thank you.
Melanie Reist wins the award for best title of a topic. Sticks and stones will break my bones, and names will cost you a bundle. Her topic is workplace bullying, and Melanie is a partner in the Kitchener firm of Morris & Reist. She practiced management labor law in Toronto prior to relocating to Kitchener. And I'm advised that Melanie is only a bully to opposing counsel, and her secretary will swear an affidavit to that effect. Melanie Reist.
Thanks, Matt. As Matt indicated, I started my career in Toronto and for a time worked with a management labor law firm. Since relocating to Kitchener, my practice now consists primarily of representing employees. So I feel a little bit like the song in the 70s that some of you might remember. I've looked at life from both sides now. And I hope that the biases that I now have won't come across too strongly in the topic that I'm dealing with of workplace bullying. Used to be when employees were in my office and they were describing to me fairly oppressive conduct in the workplace, I'd go through a checklist of prohibited grounds of discrimination under the Human Rights Code to determine if we had a human rights complaint. And if we didn't, I felt somewhat powerless in terms of identifying a clear legal remedy. Well, that's changed dramatically in the last several years, and it started to change as decisions began to carve out protection for employees in these situations based on constructive dismissal principles and a finding that it is a fundamental implied term of any employment relationship that employers treat employees with civility, decency, respect, and dignity. In my view, the door was blown wide open, so to speak, with the decision of Shaw versus Xerox Canada Limited, in which I feel a new branch of constructive dismissal law was established, eliminating the need to prove a breach of a fundamental term of the employment agreement if you can prove that the conduct of the employer demonstrates that it no longer intends to be bound by the employment contract. I'm not going to go through Shaw. Many of you are familiar with the facts. I have it in my paper. What I'm going to do is focus primarily on two decisions since Shaw to see how our courts are treating that decision and where they're taking it. The first decision that I want to deal with is that of Madam Justice Kitely in the decision of Saunders versus Chateau des Charmes Wines Limited. What's interesting about this case, in contrast to the other cases which dealt with a review of conduct over a period of time, the decision in Saunders, the plaintiff was looking at a 2-week period that he was relying upon to suggest that he had been constructively dismissed. The fact situations in these cases are always very critical, and you need to look at the oppressive conduct that's being complained of. In this situation at trial, it was discovered that Mr. Saunders' boss, during this 2-week period, regularly yelled at him, swore at him, and made such comments as, "You're off your rocker, you're insane, you need to go somewhere and take notes because I'm going to tear you apart." Not surprisingly, Madam Justice Kitely found that in this situation, the employer had repudiated the entire employment relationship without cause, and that the plaintiff was not treated with civility, decency, respect, and dignity to which he was entitled. One of the things I found interesting about this case was at trial, the plaintiff led evidence that he had prepared a draft letter to his employer during this 2-week period of intense activity with his boss, in which he brought to the boss's attention his concern with respect to his treatment. At the trial, defendant's counsel suggested that the plaintiff's failure to deliver this letter, because he thought it would make matters worse, should be taken into consideration, because had the employee brought this conduct to the attention of the employer, things might have been different. What's interesting, in response to, as if that's a reasonable approach, but Justice Kitely suggested that in response to that argument, the onus is on the employer to identify challenges in the workplace and to take appropriate steps. The obligation is not on the vulnerable employee to confront his or her employer with the wrongful behavior. Interesting to note, Mr. Saunders was 38 years old with just over 10 years of employment. He was granted 12 months notice with an additional 3-month Wallace bump out. The appeal has now been settled, and so that case is law and will not be going any further. The last case that I want to deal with is that of Stamos versus Annuity Research. Unlike a situation of a superior and subordinate, this was a case that dealt with friction between co-workers. It's also an interesting case because the judge dealt with an employer who pursued a so-called policy of equal treatment between two employees and found that that was not the right approach and that the employer in doing so failed in its obligation to provide a workplace free from harassment. Again, the facts are really outstanding in this case and you need to look at them in detail. But short and sweet, Stamos was in her 20s, was hired as a claims adjudicator. A couple years after her arrival, the owner hired his uncle, a Mr. Hamimi, whose presence had a dramatic effect on the workplace. He was irrational. He had difficulty working with women, routinely referred to them as bitches, and he and Ms. Stamos had an enormous amount of difficulty, and he harassed her quite mercilessly. The employer characterized this situation as simply a dispute of kids fighting over silly stuff, told them to get on with their work, learn how to deal with each other, or stay away from each other. Justice Dambrot concluded that her continued employment was intolerable and that it is not sufficient for an employer to take an equal approach with employees when they need to be intervening and supporting individuals who may be in need of it. This decision, all elements of it, I'm told by plaintiff's counsel, are under appeal. Thank you.
Thank you, Melanie. Marie-Helene Mayer is one of the stars from the Grossman and Gale law firm. She practices in most areas of employment law, lectures and writes, and she's fluently bilingual. So if French is your mother tongue and you go to Grossman and Gale, you'll end up in her capable hands. Today, we're in her capable hands when it comes to the subject of inducement.
Thank you, Randy. My topic today is inducement, and as the title of my paper suggests, everyone's been induced. Anyone who's changed one job from another would like to make the claim that they've been induced, but unfortunately, the court's conception and what's really going on in the case law doesn't correspond with a popular conception of inducement. We're all familiar with what happened in Wallace, where the Supreme Court of Canada formally acknowledged inducement as a factor to be taken into consideration in calculating the length of a notice period. But in order for a court to actually make a finding of inducement, and the case law in my paper sets this out in more detail, certain facts have to be present. You need more than just persuasion by the employer. You need to have presence of long-term employment, and you need to have stability of employment at the end of at the old job, i.e. no one is inducing the unemployed. But if you really sit back and think about what inducement is, it's not really clear what the legal theory behind it is, and I think this is what creates a great deal of confusion for plaintiff and defendant's counsel. After all, even though Wallace said that the period of notice could be extended, we do need some kind of legal theory. To my mind, and my thesis is that the legal theory behind extending notice period in inducement cases is that no sane person would leave a stable and long-term employment position for a new job unless it was an implied term of the new employment. And this is the key thing, that it was an implied term, that the new job offered comparable stability and longevity as the old job. So what this means basically, and the cases in my paper all hold this, is that you don't need express representations by the employer in order for there to be a finding of inducement. And that's really the whole point, because if you needed express representations, you'd be suing in negligent misrepresentation, which is another area which dovetails quite nicely with this one. At the end of the day, inducement is really a risk allocation exercise, which in my view allocates most of the risk to the new employer. And despite the fact that I do mostly plaintiff's work, I think in this case perhaps a bit unfairly. There are a number of problems with inducement. I'm not going to be able to deal with all of them, but I will address them at the end of my talk. If you look at the cases, there are a number of factors that the court consider in order to make a finding of inducement. There are several, but practically speaking, and obviously for my purposes today, there seem to be two very important ones. The first one being who initiated the job search discussions. This is almost always going to be a key fact. Who made that first phone call? Another key consideration is how many other candidates were being considered at the time. The court seems to get very indignant when one person is targeted rather than a series of people who have responded to a newspaper ad or an ad on the internet, for example. But in order to really understand how these factors work, I think what we have to really understand as well is the archetype or the model that the court has in mind when making these findings of inducement. In the model, what's really happening, I believe anyway, is that you have a loyal employee who's been working for a number of years in his or her job, who's swooped up by this new employer who seems to seduce the employee, who, but for this act of seduction, I mean, that's really the analogy, would have stayed in his or her old job. And I'm not sure that's actually the case in a lot of circumstances, because there may be lots of reasons people leave their jobs that are unrelated to job stability and longevity. If you consider the language of the cases, in one case I have in my paper, Hutchinson versus Enrich, a November 2002 decision, the language of the case is clear. The court said, in the first place, the initiative for the plaintiff's ultimate employment came from the defendant. While it is true that the plaintiff did not demur at being courted, his conduct throughout the negotiations, culminating in his employment, was characterized by caution as opposed to alacrity. So this is quite colorful language, I would say, and I think that the analogy is really one of seduction. I think that what we need to acknowledge is that this is really what's going on in these cases, and really question whether this is the most appropriate model for this type of calculation in the notice period. There seems to be a very sort of moralistic flavor underlying this area of law, when really this ought to be more of a risk allocation exercise. Another issue that I just want to bring to your attention is that if you look at the end result and you look at the notice periods, it's not always clear how much of the notice period is actually being allocated to inducement. And this creates a very practical problem for practitioners. You're trying to make the pitch for inducement. You're not always sure how much is actually allocated in the notice period. So those are my comments. Thank you very much.
Thank you, Marie-Helene. Our next speaker is Loretta Zubas. We're indeed fortunate to have her with us today. If she seems out of breath, she's just finished a race for in the bencher elections, and I gather the elections are over now and the results are being tabulated.
Doesn't matter, Randy. Doesn't matter.
You'll hear no election speech today. But the question of how to deal with disability deduction, the post-Sylvester stuff, and an excellent analysis of Sills and McNamara is in the paper. Thank you.
Thank you, Your Honor. That kind of felt okay. Excuse me while I just quench my thirst. This is one of those areas of law, and I have to, again, profess I come at this from a plaintiff's perspective, where historically, in terms of opinion or advice to clients, I kind of winged it. I can recall being at the Human Rights Commission, calling a colleague for a quick, synopsis of the law, and what I'm looking at is when disability benefits will be deducted from wrongful dismissal damages. And the pressing question used to be, well, was there any contribution by the employee to their own disability plan? The Ontario Court of Appeal, in 2 decisions after the Supreme Court of Canada decision, the leading case in this area, which is Sylvester, our Court of Appeal has kind of made the inquiry or the analysis that you have to go through a little more detailed. With respect to this question, I think it's becoming more important too. I find in my practice that I'm having a lot of plaintiffs arriving at my door who are on disability leave. There's a lot of people who are stressed out there. In the old days, everybody would stay on a disability plan and until they were well. And in terms of terminations, I found historically, back when I started practicing 10 years ago, employers were not as aggressive getting people off the payroll, whereas now, well, 2 things are working. Employers are getting more aggressive, and especially in these areas of stress leave, plaintiffs or employees don't want to go back to a workplace. So with respect to this area, you have to do some kind of an analysis with respect to disability plans to figure out what's going to happen with respect to notice period negotiations if your client wants you to start doing these. So again, the leading case, which is in my paper, Sylvester, basically, I think it was Major who indicated the line of inquiry or the question or the concern shouldn't be whether an employee is healthy or not. You basically have to look at the outset of the employment relationship and try to figure out what the party's intention was contractually with respect to disability coming up in the circumstances of a termination. This, as most people know, is a pretty impractical question to ask in the outcome of an employment relationship. I think it's very rare that employees talk to employers when they're negotiating their contracts of employment about this termination disability scenario. So what it is that happened with respect to the decisions after Sylvester is that especially our Court of Appeal in Sills and McNamara seemed to be more concerned about finding some kind of contribution or value or consideration that may have been advanced by the employee, which basically allowed them to come up with the conclusion that, in fact, if some kind of consideration had flowed from the employee, that, in fact, that allowed the trial judge, or in both the Sills and McNamara case, an opportunity to say that, in fact, disability benefits should not be deducted from wrongful dismissal damages. If you look at the decision, I think McNamara is even a more interesting decision because in that case, very specifically, the employee did not make contributions to their LTD plan, but the court still found that there was consideration or enough consideration to allow them not to have to deduct disability benefits from the notice period. So with respect to the questions, I think you need to focus in on, and you can find them at page 14 of my paper. And this is maybe more a cue for plaintiff's counsel or employee counsel than employer's counsel. you need to solicit facts from your client which suggest that there is some kind of consideration or value being left at the table by the employee when the employment relationship is entered into. And again, I think a very loose and persuasive approach or argument can always be, well, I gave up some salary to get onto a benefits plan and to basically, be able to collect both sets of benefits. This worked, in fact, in the McNamara case. Now, outside of dealing with the common law issues, there's clearly statutory regimes that come into play. The Workers' Compensation Act and the Canada Pension Plan in the disability area have their own specific provisions dealing with set-offs. The WSIB benefits, you can set off against the wrongful dismissal damages. The CPP, you can't. Thank you.
Jordan Solway is the Assistant Vice President of Chubb Insurance Company of Canada, and he is the Specialty Claims Manager for Canada. With a staff of 4 lawyers, Jordan is responsible for coverage opinions on D&O liability coverage, fiduciary liability coverage, and with reference to the presentation he's about to give us, employment practices liability coverage. Jordan and I thought that it would be quite useful for practitioners in the field to know a little bit more about how one insurer is handling the emerging area of employment practices liability coverage. Jordan Solway.
Good afternoon. Thanks, Matt. It seems when I talk to employment lawyers, you usually think about insurance in the disability context. Nobody ever thinks about insuring the actual underlying exposure, and maybe that's for good reason. So you're probably asking, how did this happen, and more importantly, why did it happen? Basically, in the early 1990s, there was more consideration in the United States for the liability of senior and mid-management for employment-related torts. And that sort of coincided with the Clarence Thomas confirmation hearings in the US, where they started to look at senior managerial responsibility for harassment. At or about the same time, they amended the Title VII of the Civil Rights Act of 1964, and they actually allowed plaintiffs to have jury trials and claim punitive damages. So corporations were now faced with potentially huge exposure. The insurance market responded for a variety of reasons. At the same time, and probably more laterally in Canada, with stock option exposure, Wallace damages, there became less predictability to employers in making decisions and termination. And for reasons which I'll go in through an actual example that we were involved in, the potential damages could just be catastrophic. Chubb is one of the largest directors and officers writers in the world, and what we started seeing around 91, 92 is that companies were coming to us and saying, can you cover our managers, our employees under our D&O contracts for the harassment exposure? And that was done sort of on an ad hoc basis. And as the exposure increased, as more and more cases were tried before juries in the US, we started to develop a separate standalone coverage and came up with this employment practices liability insurance, which is now quite popular in the US and in Canada. It's a separate policy, a standalone policy for the corporation, for directors and officers and employees of the corporation, for essentially, at least in terms of Canada, for the non-unionized exposure for contract and tortious damages. And what the coverage responds to, and this is the material I've given you, loss on account of a claim made against an insured during a policy period. In insurance speak, it's a claims-made policy, so you have to be sued if you're an employer during the policy period. And what you're insured for, who's insured, is obviously the corporation itself and its officers and directors, as well as employees, whether they're past, present, or future. It must be brought, the claim must be brought by a past, present, or prospective employee. What that means, a past employee is obviously the wrongful termination exposure. A present employee could be the harassment discrimination exposure, and prospective could be hiring exposure, hiring practices, like the Queen versus Cognos, where there's misrepresentations made. And the insuring agreement is quite broad. What it covers is a claim made in connection with any breach of a written or oral employment contract, any claim for wrongful termination, wrongful discharge, constructive discharge, You got to ask yourself, if you were the TD Bank, whether in the Schumacher case, having the coverage would have been useful. Violation of discrimination laws, employment-related misrepresentation, that's the Cognos situation, privacy issues in the employment context, negligent evaluation, employment-related distress, and employment-related infliction of emotional distress. One thinks of the Prizzo case against Baycrest. As well, employment-related defamation, wrongful deprivation of a career opportunity, harassment, wrongful failure to employ or promote. So it's very wide in terms of the ambit of coverage, so you're probably asking yourself, then what do we not cover, which always is central in an insurance contract. There's really three main things that aren't covered. As I said, it's the non-unionized common law tort exposure. So we're not covering anything to do with the collective bargaining process, except and unless there's a retaliation issue. If someone is claiming wrongful termination because you tried to organize, or they were constructively terminated because they tried to organize the workforce, it's going to respond. The other main exclusions deal with exposures covered under other insurance. For example, a physical assault would be covered under a general liability policy. There is coverage for mental anguish-related damages. And the final thing that isn't really covered are unjust enrichment. If someone is suing for wages for services already performed, I'm not talking about notice period damages, but just they did the work, they want their money, it's not going to respond. I can't do better than talk about an actual case that we were involved in. And I'll go through the facts quickly. It was a high-profile termination, and basically what happened was it was the CEO of a subsidiary of an American parent. It was a private company, but there were stock options. There were basically phantom units that were valued every quarter. The total package was about $500,000 plus, and what basically happened was in 1999, as part of a worldwide effort to promote succession planning, they started to talk about retiring their senior executives, and the CEO was one of them. And there was an informal discussion between senior management, as is always the case at this level, about having the CEO retire. She understood from the conversation that she would be retiring when she decided she didn't want to work any longer. They understood that she was going to be retiring at age 65. Now, there was a mandatory policy, but unfortunately, it had never been approved by the board. So it never had been in writing. So what literally happened was, in the summer of 2000, they come to her and say, we want to plan your retirement party. And she says, well, that's great, but I'm not retiring for a couple of years. And they said, well, actually, you agreed to retire effective January 1st, 2001. And she said, no, I didn't. And they said, yes, you did. And she sued for wrongful termination. And they said that you had voluntarily resigned. What was significant about the case was, because she'd been with the company for so long, the exposure was anywhere from $0 to $6 million. Because not only was there a significant notice period, there also was potential Wallace exposure because they also misadvised her on her pension calculation. They told her it wasn't based on stock options after the fact. She thought it was based on stock options. So there was a Wallace exposure. There as well was valuations on shares that she was forced to give up, and they were to repurchase. So the policy responded for the wrongful termination damages, and we paid out. The policy responded for the notice period damages. We settled it at mediation. So we paid for all the salary during the theoretical notice period, including bonuses, stock options, her leased auto, RSP matching. She also sued for the pension adjustment, saying that they had contractually agreed to provide the enhanced benefit based on the stock options. We only provided defense cost coverage for that aspect of the claim, and that comes back to the unjust enrichment. If they agreed contractually to provide her with the increased benefit, then they were responsible for it. If they hadn't so contractually agreed, then they weren't responsible. So the case ended up settling, and we paid out over $1 million. The total settlement, I think, was about $1.5 million. And I think it really sort of puts to the forefront how employment liability can be catastrophic damages to a corporation. And if you're advising your company, given the waves of retirement that we're all facing and the sheer lucrativeness of a lot of employment contracts, the exposure can be significant. Thanks very much.
Do you want to move the chair? I'll just stand up. We've saved the best for last. Matt indicated that, again, in response to questionnaires, we set up a panel at the end of the 6-Minute Lawyer program, and I'll ask the panelists to come up now and we'll reconfigure. And we will bring the railway back in on time, as we promised. I'm glad that we've got 4 outstanding panelists. The first is the Honorable Mr. Justice Ian Nordheimer, Ian was a partner at Fraser Milner Casgrain and a top litigator. I had the privilege of litigating against him once years ago, before April of '99, when he was appointed to the Superior Court of Justice in Ontario. He has a well-earned reputation of being a hard-working and diligent member of the bench, and starting later this month, I'll be looking forward to working with him. Peter Israel is a fellow who's given me all kinds of advice over the years. He's a Lexpert Top 500 lawyer, a leader of the Human Resources Management Group at Goodman & Carr, and a dear friend and a top practitioner. Kathleen Kelly, we're fortunate to have, is the most recent recipient of the 2003 Ontario Bar Association ADR Award of Excellence. Her practice is primarily as a third-party neutral. She does private mediations as well as roster mediations, and is a published author. And finally, my dear friend and a former colleague, Christine Thomlinson. Chris, for 7 or 8 years, spent her life making me look good at BLG. She is a top-notch employment lawyer and a senior partner at the Ruman, Manning & Thomlinson firm. She was and is the driving force behind an outstanding book called For Better or For Worse, A Practical Guide to Canadian Employment Law, which was first published 7 years ago. I'm pleased to advise that a new and improved second edition containing such exciting cases as Wallace and McKinley will be coming out shortly. Ladies and gentlemen, I'll turn this panel over to Matt.
Okay, we're going to start with a relatively well-known current event affecting workplaces, SARS. It seems that we should be timely, and I think all of us have probably had to deal with an issue arising out of the effect of SARS in the workplace. So we thought we'd start off with Christine and Peter addressing some of the workplace issues related to SARS.
Not sure what the best order is to go in. I actually, as I thought about this, I thought that maybe perhaps instead of recapping some of the legal advice that we found ourselves giving over the last few weeks, and perhaps Peter can speak to that, that I would do a little bit of unpacking, because I met with one of my good clients yesterday who's at a large employer, an HR professional, and so I had a bit of a brainstorming session with her about, now that the crisis seems to be somewhat over, what kinds of looking back are you as HR professionals doing, and I thought this might be the kind of advice that we could be looking to give to our clients sort of post-crisis. So as we talked about it, one of the things that was quite interesting is I think SARS has caused us to really start to question some of the contingency plans that our clients had put into place post 9/11. Post 9/11, of course, the contingency plan model was really based on finding an alternate location for work, and companies were focusing primarily on making sure that they had an alternate location for their employees to do business. And SARS really called all of that into question, because all of a sudden you could have an alternate place to work, but if that similarly became infected, what did you do? So it really causes employers to challenge the traditional model. And I know that what appears to have happened over the last few weeks, primarily towards the end, I think, of the crisis, is that employers are starting to think about creative ways to perhaps address future outbreaks, which I think is wise. If we look at even the coming of the potential West Nile virus this summer, and my guess is that over future years we're going to continue to see incidents like this one. I mean, we hope not, but we probably should expect that. That employers can look at putting plans into place that might help them address this sort of thing in the workplace. And some of the things that you may have heard of in the last few weeks, I know that a lot of our clients were looking at putting clean teams into place and trying to find ways to separate their workforce so that they could keep one portion or some portion of the workforce uninfected. And we had many conversations over the last several days about the effectiveness of some of those clean team strategies, and I'm not sure that we're at any kind of a perfect model yet. And a lot of that, I think, will depend upon the particular illness that is in question, because a lot of the difficulty here was really knowing how the disease was being transmitted and to what extent. So I'll just float that out there in terms of revisiting, perhaps with some of your employer clients, the effectiveness of contingency plans. One of the other things that was interesting, sort of post-crisis as well, was it also calls us, I think, to challenge to some degree the models that our employer clients perhaps have in place for attendance programs, because it's interesting, but many employers reward their employees for perfect attendance or for substantial attendance. And all of a sudden, the SARS crisis was calling that hugely into question, because employers were starting to very much desire many of their employees not to attend work. And so particularly with, I think, a period of time when we have all sorts of flexible and alternate work arrangements, what I think might come out of the SARS crisis is employers looking at ways that people can really do meaningful work away from the traditional workplace, and perhaps use that as a way to develop alternate contingency plans for this sort of thing.
What troubles me the most about SARS, as I've been sort of thinking about it and experiencing it with clients, is the horrible realization that occurred on behalf of employers that the concepts of due diligence might well not apply to the situation. So that while all of us have been trained to advise employers to post signs and do education about washing hands and not coming to work if you're coughing, etc., what happens in a situation which I'm afraid we are going to face, of an employee coming to work exhibiting symptoms, the employer either not being aware of the symptoms or not reacting to the symptoms, and 2 months later 4 other employees unfortunately have contracted the disease and or have passed away. And I think in light of the trilogy of the Supreme Court of Canada decisions 2 years ago, I think that employer is vicariously liable. And I think that employer may well be vicariously liable even if the employer had gone through the due diligence of saying to employees, do not come to work if you demonstrate any symptoms. If we discover you to have any symptoms, you are going to have to leave. And even in light of posting or education of that kind, I am very, very concerned that in this day and age there would be vicarious liability on the employer. So for what it's worth, that's what worries me. In terms of the actual employment standards kinds of things, I don't think we should sort of waste any time. I mean, obviously one has the 10 days emergency leave for those employers who have more than 50 employees, and employees would be entitled, of course, to claim that. The employment insurance has obviously been amended so that people have some of those rights. I guess a more difficult question is it cause to dismiss, or could it possibly be cause for dismissal if an employee refuses to come to work? People talked about the obligation of an employer to put health and safe environments in place, and there is WSIA kind of claim ability.
Okay, before I go to the next question, Jack Siegel has just reminded me and suggested that I bring everybody up to speed, if you haven't already noticed, that Bill 1 adopted, I guess 2 days ago in the legislature, amends and expands the ESA emergency leave provisions such that that it'll apply for employers with more than 10 employees.
More than 10 days if necessary.
And more than 10 days. Is it still the 50 employee cap, though?
Not sure. I've only seen
Okay, so all of us, I guess, are commended to review the legislation just passed on Wednesday, designed to widen the protection for employees under the emergency leave provisions affected by SARS. Our other two distinguished panelists can give us a very interesting perspective, I'd suggest at the outset, from their respective perches as mediator and judge. So before we go to some of the questions that have been passed up, I might just start with Justice Nordheimer and then Kathleen Kelly, judge and mediator respectively, and ask them just to provide us with maybe a couple of comments about what they're seeing of late.
Well, I don't know whether you call them trends or recurring themes. There still seems to be a lot of confusion over the application of mental distress and Wallace factors among, particularly, I will say, counsel for plaintiffs. I don't know whether Mr. Justice Rosenberg's decision in the Court of Appeal on Tuesday will help alleviate some of that confusion, but it's a very well-written decision dealing with the issue of the application of Wallace. There seems to be an increasing emphasis by defense counsel on the issue of mitigation. perhaps because we've had a pretty good employment run the last few years. And one interesting issue I think that comes up in that context is how far geographically a dismissed employee can be made to look for a job in this day and age, whether they can simply say, I can't find any in the city of Toronto, or whether they have to go further afield. And there still also seems to be an issue arising from UI applications and what happens when hearing officers make determinations and whether or not that precludes the relitigation of those issues in a wrongful dismissal action. The issue of issue estoppel is one which, due respect to the Court of Appeal, seems somewhat muddied at the moment. When it can come back to haunt the employee if the UI officer makes an adverse finding. But those are the three areas that I see that seem to keep popping up in terms of employment law matters.
Hi. With respect to what's been happening out there, sometimes what happens, in fact, it's occurring more frequently than not now. When pleadings are being drafted, plaintiffs' lawyers are drafting in, if they can find any supporting base for it, a tort claim. And by doing so, that helps often create or expand the pie to find other ways of making a settlement that might not otherwise, on its bare face, be able to be made in terms of notice period. So it's an opportunity to shield payments in a way that is within the four corners of the law, to use the tax analogy, and amenable often to employers and certainly acceptable to employees. So that's something to bear in mind. So if you're defense counsel, don't be too quick to try to discard that claim, because it may help you, as I said, expand the pie and find more creative ways of handling matters. A question that's really critical to be asked is, does Rule 76 apply? Should it be a simplified rules case? And if it should be real careful about the possibilities for costs, penalties. The flip of that is, if it is a Rule 76 case and you're not going to bring it in under the regular process, think about using mandatory mediation in that context, because if you contact mediators who are on the roster, they will mediate 9 times out of 10. They will mediate your simplified rules case within the confines of the regulation under 24.1, Rule 24.1, which is the tariff. So in other words,
for the roster fee?
For the roster fee, but you have to ask them up front. And of course, remember, that only applies for the first 3 hours, and there's the preparation time in there.
Sorry, Kathleen, I know everyone was thinking that question, so I thought I'd ask it.
Right. No, I mean, there are some mediators who will not take cases under the roster fee under any circumstances at all, but there are a lot of excellent mediators out there who are on the roster who will. They'll even take private cases if the circumstances are apt, and in those circumstances, I'm thinking about where the amount of the claim is pretty small. And there's a real concern that legal fees and mediation fees and court fees and everything else would eclipse the settlement that would finally find its way in the client's pocket at the end of the day. So there are possibilities out there, so be bold, ask the question.
Can I comment on that?
I was going to say, Counsel, do you want to comment on trends in mediation?
I just wanted to comment on something Kathleen said, because I find that now even members of the judiciary who are getting more and more proactive in their efforts to mediate cases at pretrials are trying to push upon counsel the concept of heads of damage to settle wrongful dismissal actions, which the CCRA will simply not permit. I find it very, very frustrating when a mediator trying very much to do his or her best, or for that matter, a pretrial judge trying to do her best in this province, to cause a settlement will actually impose obligations on the employer that the CCRA will simply not approve. And it's sometimes difficult to demonstrate to that mediator that while his or her efforts are valued, it's just something that they are suggesting an illegality. So I just thought, in fairness, to balance.
Now,
what
are you
said.
suggesting that if that in the context of there is a pleading to support that kind of characterization?
Absolutely.
Even in that context?
Well, depending on what the head of damage is, but
Okay.
the CCRA is very clear that many heads of damage that one thinks of as torts in an employment situation are simply taxable, no matter how you describe it.
I was just going to say, I also, we had the thought during Geri Hart's talk as to how long it would take CCRA to figure out that human rights damages were increasing and to take a stab at getting those as well. So I wonder.
Okay, I have a portable mic, which means I get to do the Phil Donahue shtick if anyone wants to ask a question. I've got some handwritten ones, but I'm prepared to run around. Questions? All right. Yes, go ahead. Hang on, let me run up, because I want to record it. Hang on. Here you go.
One of the early topics was on accommodation. And I mean, from a practical level, it's always very difficult to determine to what extent somebody has an obligation to accommodate, what change you need to make to that particular employee's job in order to fulfill your obligation. Sometimes it's easy when you're talking about extremes, but in cases where, and these are the types of cases that you get calls on fairly regularly, and that is, one of the duties of the job is to lift items that weigh 50 pounds. There are other people within the workplace that can lift 50 pounds. This particular employee can't because of a back injury or whatever, but they're a shipper-receiver. Lifting 50 pounds is, 80% of the job. The other part is filling out the paperwork after you've lifted the box. In that context, from a practical level, and I guess I'm speaking primarily to counsel, what do you do with the employee that's essentially coming to the point where they can fill out the paperwork and their coworkers are very upset about the fact that they no longer have to lift the boxes? I mean, what types of suggestions do you make to those employees or employers, I guess?
I think the paper that was presented on accommodation was bang on in terms of the kinds of things that an employer has to consider. And I think the struggle we have when we give advice to employers is that you've got to balance what now appears to be an extremely high bar for the test of the undue hardship test and the lengths that you have to go to and what you'll have to demonstrate to a board of inquiry or to a court. You're going to have to really show that from a procedural point of view, all different things were considered. And if any of those things could have been done, short of undue hardship, which suggests by its very definition some form of hardship, and clearly the onus will be greater for larger employers. Balancing that against what is perhaps the reality of the human rights process. I mean, there's a mediation aspect to it that if the complaint is in fact lodged, in all likelihood may settle. So, we give this advice to our employers where we say, be careful, do this, do that, make sure you've done all these things. At the end of the day, we can't guarantee that you're going to meet the test in any event, but gosh, if the person does complain, we're going to go to the commission and we'll probably settle. So there's sort of the practical take on it. That's, I think, how we're struggling with it these days.
I guess also the difficulty, Chris, as you know, is that you have to distinguish between work injury, where I think the WSIA obligations are severely different and more complex than if it's not work-related. So that if the inability of in your example of that employee to continue to lift is not a work-related injury, I think your duty to accommodate under human rights is very, very different and far lesser in degree, because I don't think that you have to cobble a job together. I think you have to accommodate the person to carry out the bona fide duties of the position, as opposed to under the WSIA system having to cobble a job together so that the person can do less duties in that position. And so I find that I try to approach it contextually in terms of that, and I absolutely follow Christine's views. The end result is that I try to achieve a resolution that solves both the employee's problem and the employer's problem.
Those are a couple of pretty good answers, wouldn't you agree? Okay, I have a question over here.
Any advice for small employers who, although they may have third-party LTD group policies, self-insure on short-term, and then when a claim is made, the employer asks for adequate medical evidence, and either the employee or their legal advisor says, I'm not going to give that to you because that's personal, private information, or if I gave it to you, you're not qualified to contradict the medical evidence in any event, and how you deal with that?
Well, I guess if it's an accommodation issue, and sometimes it is depending upon whether there are restrictions or modified hours that are sought throughout the period of disability, then I think by law you have an entitlement as an employer to request that information, although the kind of information that you can request is pretty particular. And as an example of this, we're dealing with this for one of my employer clients right now, where we're trying to figure out how to have a woman with epilepsy at work, because she's having seizures that are unpredictable and that are having an extraordinary impact on the business, and she's having them at an extraordinary rate. So what we did was we crafted a medical form to the doctor, which had very, very specific questions about the impact of the seizures on the workplace and whether anything could be done to assist the employer in predicting them, in working with the employee to try to prevent them or lessen their frequency. I think if you think about a request for medical information, and you can distinguish what would be confidential information about somebody's file or their history versus what you could probably justify as contributing towards the accommodation process, that's going to make it a bit of an easier exercise. Do you want to address, Peter, the just blanket request for medical?
Well, I just find more and more with the advent of privacy in legislation that for larger employers where we have actual nursing staff interposed between the employee and the employer in order to deal with privacy issues, the employer is getting to the point where if a lawsuit arises, you can't get the information from your own nurse in terms of any of that. So I agree it's a difficult area.
Okay, in a totally Phil Donahue-like moment, I'm going to go to the audience to ask and answer a question. There's a question for Hugh Christie that came from another audience. Why don't you read the question and then answer it, Hugh?
Do you want to read your question? That gives away who asked the question. What's the risk of having a company policy that you simply do not give references, but that the employee should instead use their written periodic performance appraisal documents that they've been given periodically to appraise them to subsequent employee, right? I don't know how they came up with that name. I think the answer is the goal for an employer is to act in good faith and to be able to prove that they acted in good faith. And so the answer is that procedure is only as good as those appraisals are. If those appraisals are fulsome in all respects and have been carried out in a fulsome manner in each case, both of those are big ifs, then to say we're going to use those because we think that we're acting in good faith and they give you the opportunity as an ex-employee to go to a subsequent employer and have that employer evaluate your performance here in a fulsome manner, then you're closer to being safe. If, on the other hand, they're not, you're no further ahead. And in fact, if the employee can show that they're pretty perfunctory too, or they dip into gossip, or they weren't agreed to by the employee periodically when they were appraised, then you still got a problem. And tough cases are still going to be tough, and rules like that fashioned in advance hardly ever work in tough cases.
How about a panel? Anyone disagree or agree?
I was just going to add something to that. The other danger, I think, is that some employers who do hiring have a requirement that a reference be given. And if it's clear that the employer's failure to do so prevents them from applying for and ultimately obtaining a job, that may very well contribute to a damages award.
Yeah, the only other comment is that I don't think I've done a wrongful dismissal settlement in 20 years without one of the terms of settlement being the negotiation of a reference and what it would say, and advising the employee to test that reference by having a friend call, so that and you bind the employer to saying only that which is in the letter of the letter or the spirit of the letter of reference.
Okay, I've got a great question here from the audience. With respect to SARS, could a just cause dismissal be upheld where an employer advises all employees not to report to work if they have been exposed, and an employee does report to work, thereby potentially exposing all other employees to a life-threatening disease? Hang on, I'll buy time before anyone has to answer. We'll go to a commercial. That's it. We'll go to a commercial. Now your sponsor, Pfizer. Now your sponsor, Chubb. Where's Jordan? Anyone want to take a handle? Is it just cause for someone to come to work and put other employees at risk? Let's let's narrowly talk about it.
Conceptually, it is. I guess the question is, what jurisdiction are we in? Are we in Ontario? Because the answer is it's not cause. Conceptually, it is cause, but isn't the answer that the employer would have an obligation to be aware of that or to be on top of the situation sufficient to simply not permit that employee to come to work in that specific situation? So, I mean, if you want to answer the question in terms of legal concept, exposing the asset base of the employer or the employer staff to that kind of disease, I think could conceptually amount to cause. Put it into pragmatic terms, I don't think you're going to get there.
Yeah, I think that's exactly right. From a theoretical point of view, you might be there, but when you think of all the particular factors of a case, and you know, the questions the court is going to ask is, why did somebody come to work? And unless I think you can demonstrate that they did it to infect the workforce, chances are they probably felt like they had a good reason, and that's going to impact on a court's decision. A court will also probably be looking at it in hindsight, so that they're going to have the benefit of knowing how serious the illness really was. And even if that's not information that was necessarily available at the time, I think it's going to have an impact on the court's decision-making process, as is the availability of other disciplinary measures. If somebody's caught outside on the way in and an alternative is to send them home instead of firing them, I think that's going to be relevant.
And you know that you have the TTC grievances right on that point now, so.
Well, what if, I mean, if an employee fails to follow lockout procedures, many would argue, even if it's a single incident, that would be just cause because of the severity of the risk put to the other employees. Isn't SARS in that same sort of category? I'm trying to be provocative. Doesn't Phil Donahue do that? Oh, come on!
I think, you know, the timing is so critical in all of these. We're in a post-McKinley judicial climate where it's just going to be very, very difficult to establish. And I think, you know, if you're looking at a SARS case today, when a court's going to have the benefit of saying, gosh, that SARS thing, what was that? That was ages ago. It may not have the same impact.
Okay, I've got a question back here.
One of the speakers earlier today talked about employment contracts and imposing them on existing employees and the consideration required. And I wouldn't mind, this is one of the questions that I face with my clients all the time. They get sued and they say, well, how could I have prevented this? And you say, well, employment contract. Well, what about my existing 20 employees? And I tell them, well, you could give them a signing bonus, and then, of course, they want that to be $10, and I'm telling them it ought to be a little more than that. Does extra vacation help? How much of a signing bonus would be helpful? And I wouldn't mind hearing the view from the bench on that as well.
I think what Neena was trying to say, and the case is, I'm not even sure you need the extra signing bonus, and I don't think you need the extra vacation. I think if you go back to there were 3 cases at the Supreme Court of Canada level back in the 30s. They basically stand for the proposition that if there is forbearance by the employer, right, and there is continued employment, that is sufficient consideration. I'll give you a practical example in which I was involved some 4 years ago, and I'll try to be quick now. 4,000 nurses. Government pulls back funding, right? So what you say to that group of employees is, that my economic reality requires that moving forward, I want to have employment agreements. These are the types of employment agreements that I need to put in place, right? If you are not willing to sign these agreements, I respect your right, but I will have to terminate your employment. When I terminate your employment, you will be entitled to everything that you would have received at common law. Please let me know within 2 weeks whether this is agreeable, and you have the right to negotiate it with me. I think that in that situation, if that contract is signed, that contract will hold water. Negative, of course, is, as Neena said, it's bad for morale. I mean, it's difficult to sort of sell it on that kind of mass level. On the other hand, sometimes it's necessary, and we do it on a regular basis. If the employee signs that contract, I think that contract is binding. If the employee does not sign that contract, I think the employer must act on the first letter and terminate. But the good news is you can terminate by providing reasonable notice of termination, because that's a good employee, and being generous on it. So 2 years from now, you don't have a job. Out of the 4,000, I think after the second phase of it, where people came back realizing that the employer was serious, I think I had 3 allegations of wrongful dismissal which settled before discovery.
Anyone else? Okay, I've got a question here then. In the middle ground dependent contractor case, does the Employment Standards Act come into play, i.e. in assessing the minimum notice for termination set out in the contract? In other words, should Aqua have received the employment standards minimums, or should Aqua's, this is the case, the Aqua, it's underlined, Aqua's termination at will clause been struck out not because of unconscionability, but because of Mackinger and Hodge?
Yeah, sure, point to me.
Say yes.
I confess that I'm not up to speed on all of the dependent contractor cases, but my recollection of looking at some of them is that what they do is distinguish between still an employee and a contractor. And so I think you could make the argument that somebody who could have a notice provision implied into an otherwise contractual relationship could still nonetheless be seen not to be an employee.
The ESA definition of employee is more and more following suit with the labor relations concept in Ontario, as Matt of course knows, and the concept of dependent employee or dependent contractor is in the legislation. So I think ESA would find that person to be an employee for the purposes of ESA standards. The only comment in terms of that same speaker, I was surprised actually, because the Bell-Carter decision has been around since the 50s, so I don't think it's new law to say that there is this middle category. It's been around, at least according to the Ontario Court of Appeal, since the 50s.
I thought that was 1936, wasn't it?
36, Bell and Carter?
Wasn't Bell and Carter 1936?
No.
Something like that. Do you have a question? Oh, here's a question.
Many, many years ago, the Liberal government promised to enact a strong and effective Ontarians with Disabilities Act, which we're still waiting for. Do you think that once a strong and effective ODA is passed, do you think that'll go any length towards changing employers' mindsets on what accommodation really means and what it means to accommodate, and basically including everybody in the workforce?
Hang on, I don't mean to interrupt or be partisan, but I thought the Progressive Conservatives were in power. Anyways, anyone on the... Sorry, I couldn't resist. My red tie gives me away. Anyone want to comment?
I think it might make a difference. The sense I get is sort of post-Mayorn and Grismer that the conversations that I'm having with my employer clients are much more educational, and that they're starting to listen, that, you know, as we talk about the knee-jerk reaction to any discussion about a request for accommodation is, from their perspective, you got to be kidding me that I would have to do this, we'd have to do this. And as we unpack it and talk about what is an employer's role to be a member of society, a good corporate citizen in contributing towards the accommodation process, I think they're listening. That's not true of all of them, but I think some of them are listening, and it may very well be that as we move towards that, it may make a difference.
Justice Nordheimer has a question in front of him which essentially takes us back to the consideration issue and the apparent inconsistencies in the way that the very difficult doctrine of consideration is applied. Justice Nordheimer, do you want to address at least the answer, if not the question?
Well, the question says continued employment. I can't even read the writing here. Let me try it this way. Continued employment often not consideration for a new contract, therefore the new contract is unenforceable, but an employee who does not object to changes to his terms of employment may be deemed to have condoned the change. Aren't these inherently contradictory? And Randy, you'll have to get used to saying this. It depends on the facts. I think on the surface they do appear contradictory, but I don't view them as such. It seems to me that they're just two points on a spectrum of employer activity between moving from what is permissible to what is impermissible. And this relates to a lot of issues in employment law. Never underestimate the power of fairness when you're dealing with these issues. I mean, a lot of these issues come down to does it appear that the employer dealt with the employee fairly? It's one thing to walk into an employee and throw an employment contract down on his or her desk and say, sign it or you're fired. It's something else for an employer who honestly needs to change certain terms and conditions, such as commission rates for commission-paid people, to sit down with his or her employees and say, look, we got to make a change for the better, for the survival of the business, and this is what we intend to do, and this is how we intend to do it, and they give them a chance to get advice and react. And then if nobody complains, why shouldn't the employee be bound?
Okay. There's a question I just passed up to Kathleen on inducement. The question, I think, if I remember correctly, talks about headhunters and the impact of the recruitment industry on the issue of inducement. But I want to maybe broaden it to, from your perspective, Kathleen, both with respect to the specific question and generally in the context of mediation. Maybe you could comment on the impact of the inducement allegation on trying to achieve resolutions in the mediation process.
Okay, thanks, Matt. The question is, what about the effect headhunters and the seduction when the employee is on file with the headhunter? It comes down, again, to the basics in terms of preparation. What role did who have in what part of the dance? Did the headhunter go to the target employee and say, I've got the perfect assignment for you, and did the headhunter build it up? And did the headhunter build it up with the permission, either implied or very open, of the employer, of the corporation? And whose inducement is it? And when that occurs, it's a matter of what does the documentation show, what does the prior history show, what does the employer have to say about it? Is the headhunter now another party to the action because of representations? I don't know. And there is a second part of this. The probation periods with new employees, does that negate seduction? I'm not quite sure what the questioner meant here. Okay.
Where you get into a new employment contract.
You have to wait for Phil Donahue, please.
Okay, thanks, Matt.
When you come into a new contract with a new employer and the employment contract says there's a 90-day probation period, but you've been seduced from a secure employment, is that going to be a bar to the inducement?
In terms of, would it be a claim that could win? If you know there's a 90-day probationary period, and you leap from what is nice and cozy and secure into that abyss of 90 days of uncertainty, you do it, one would hope, on a fully informed consensual basis. And if it is on a fully informed consensual basis, then that answers your question. You wouldn't have the ability, I don't think, to hang on to that. Now, you've just asked a facilitative mediator to provide an evaluative matter.
Not bad of me, eh?
So I'm just going to take the string for a moment and go back to something, and that is the lawyer's job in the mediation is to know the law and to argue the law if it's appropriate. It's not the mediator's job to argue the law. In caucus, the mediator might raise questions and say, well, what would happen if? So long as you don't do it in the joint session and blow your impartiality or blow one person's case or another. That also means if you think the mediator is starting to tell you what the law is and you don't agree with it, stop it right there, because that's not why you've got the mediator. If you want an arbitrator, that's a different story. So that's my 2 cents worth, given the open door.
Worth much more than 2 cents. Thank you, Kathleen. We've come to the end. Are there any last comments on any of the last items raised? All right, well then, join me in thanking the panel. Before you leave, I want to remind you that it's of great assistance to us if you will fill out the questionnaire. It's also of great assistance to us if you'll suggest topics and volunteer to be on next year's faculty. Randy and I can't believe another year has gone by. Thank you all for coming.
Pleasure, sir.
So you didn't have to speaking to this morning
I know that. You must be screaming the iron somewhere.
It wasn't a plan. It came down fast. Last chance for third grader. Congratulations to you. Caesar's way.